So good afternoon, everyone. I'm Nan Aaron, President of Alliance for Justice. Thank you so much for joining the latest in our virtual Holding Court series, featuring leading advocates, lawyers, and elected officials to discuss issues related to our courts, our rights, and our justice system. And thanks also to Alliance's wonderful outreach and communication staffs. We are honored today to be joined by Congressman James Clyburn, the House Majority Whip. We're also thrilled to be joined by Kimberly Atkins Stohr, Senior Opinion Writer and Columnist at the Boston Globe, and Adam Jentleson, author of Kill Switch: The Rise of the Modern Senate and the Crippling of American Democracy. Our discussion today couldn't be more timely. Just yesterday, President Biden, in an eloquent address in Philadelphia, made clear that our nation faces the worst challenge to our democracy since the Civil War. State after state, from Georgia to Texas, we've seen them advance voter suppression laws designed to make it harder for persons of color to exercise the franchise. And just 8 years after the bludgeoning of the Voting Rights Act in Shelby County, Republican appointed justices on the Supreme Court this term yet again gutted one of the most important pieces of legislation ever enacted by Congress. The House of Representatives has acted and passed essential legislation to protect our democracy. The American people overwhelmingly support it, as does a majority of the Senate. Yet that bill is not law, and it is because our democracy is being held hostage by a minority, abusing the filibuster to entrench themselves in power. In order to repel the threat to our democracy, reform of the filibuster is necessary. And that is why this conversation today is so important. This is not a new issue for Alliance for Justice. When the Republican minority used the filibuster to block President Obama's highly qualified judicial nominees from getting a vote, we demanded an end to it, and Harry Reid ended it. We had no choice then, and we have no choice now. In too many critical areas, an extreme minority in Congress is trying to prevent critical legislation in all areas from being enacted. Our conversation today will be moderated by Alliance for Justice's legal director, Daniel Goldberg. Mr. Goldberg previously served as senior counsel to Senator Tom Harkin when Harkin was at the forefront of the fight to change Senate rules over a decade ago, when Mitch McConnell did all he could to break government and obstruct President Obama. We'll have a conversation for approximately 45 minutes and then open it up for questions from the audience. You can submit questions throughout the program by emailing rachel@afj.org or use the question and answer submission feature on Zoom. One other point, and that is live captions are also available. And with that, I will turn this over to Daniel Goldberg. Thanks so much, everyone.
Thank you, Nan, and just a great honor and privilege to be on this amazing panel, including with one of the great legislators in our country today, Majority Whip Clyburn, somebody who has been at the forefront in leadership in passing critical legislation through the House of Representatives, not just voting rights legislation, but in countless areas that, if enacted into law, would make such a difference in improving the lives of the American people. So really just an honor to join you, Congressman, and join Kim and Adam in this critically important conversation. I'd like to begin actually by talking about the legislation that has passed the House of Representatives. Our constitutional system was designed so that the American people could come together through their elected officials to solve problems facing the public. And yes, to deliberate, yes, to consider various viewpoints, but at the end of the day, to act. Unfortunately, far too often, because of the abuse of the filibuster in the Senate, the filibuster has been transformed into an undemocratic tool preventing the American people from acting. I'd like to get your thoughts initially, Congressman Clyburn, and then Kim and Adam, for how can you explain to the people listening today how our government is functioning and not functioning, and the role the filibuster on the other side of the Capitol plays?
Well, you know, you can make the attempt. I don't know if people really understand it. I'm amazed at the number of people who are really still aghast at the fact that we have this tremendous, I don't know what to call it, problem with getting legislation done. People really feel that they voted for change last November and they're not getting that change. And I noticed in recent days, frustration growing significantly, which is one of the reasons I kind of ratchet up my activities over the last several days. Tonight, I'm having the fifth of 6 town hall meetings that I've been having. And it's really amazing to listen to people, to experience the level of frustration, all of which has been complicated by COVID-19. As you know, I chair that select subcommittee as well. And I can tell you, we are at an inflection point in our history. The president said in his great speech the other day that, you know, this is the, I think he likened this as the most serious democratic issue since the Civil War. Many of you may recall back during the campaign last year, I called last year's campaign as the most consequential since 1850 or 1860. And I said that about 1860 because that's when Abraham Lincoln was elected. And that's what changed the direction of things. The Emancipation Proclamation, both of them he signed in 1860. Well, one of them is 1862, the other was a piece of legislation. But you know, we are at that kind of a point today. And another thing I think we have to get people to understand, people think that Reconstruction was this thing that started after the Civil War and continued right up into the 1900s. Few people realize it was only a 12-year deal. Reconstruction was over after 1877. And then we were stuck then with Jim Crow laws. And so when the president calls this more than Jim Crow, he is absolutely correct. Because if you look at what ushered into Jim Crow and what really caused all those things that we are highlighted by the 1921 Tulsa riot, when you go back and you will see that was just the latest one, maybe the most high profile one, but we are at an inflection point in the country today.
So for voting rights or other piece of legislation to become law, right now, 60 US senators, including 10 Republicans, have to agree to it because of the filibuster. Adam, I want to turn to you to give a little sense of the history of the filibuster. I think when most people think of the filibuster, they probably think of the climax of the classic film, Mr. Smith Goes to Washington, where Jimmy Stewart's character single-handedly uses the filibuster to stop a piece of corrupt legislation. But the reality is that in 1939, the year that movie was made, there were 0 filibusters in the Senate. So I think most people think the filibuster is in the Constitution, and the idea of a supermajority to enact legislation is just common practice throughout history. Can you give our listeners a sense of what is perhaps unique about the current moment we're in?
Yeah, absolutely. I mean, I think that the number one thing for people to understand is that this idea that it requires 60 votes for bills to pass in the Senate is a very recent development, and was not what the framers intended at all. You mentioned Mr. Smith Goes to Washington. I think, in some ways that movie did a very dramatic disservice to the filibuster because it sort of whitewashed its use. You mentioned that it came out in 1939. In 1937, when the movie was in production and right before it came out, the filibuster was used to stop an anti-lynching bill that had passed the House of Representatives, that was supported by a majority in the Senate, and was ready to be signed by the president at the time. Mr. Smith portrayed it as this noble cause, but the fact is that during the Jim Crow era, when the movie came out, the only category of legislation that the filibuster was used to stop bills altogether were civil rights bills. Congressman Clyburn mentioned, the end of Reconstruction 1877. Well, from the end of Reconstruction 1877 until 1964, the only bills that were stopped by the filibuster were civil rights bills. For those 87 years, that was the case. Other bills on other categories occasionally would run into a filibuster, but on those bills, the issue was quickly resolved. The filibuster would usually go away within a timely fashion, and the bills eventually came up for a majority rule vote. So, just to briefly sort of give a sense of the history, there was no supermajority threshold in the original Senate. The framers were very clear that they didn't want one to exist. They were wrong about a lot of stuff, but they were right about this when it came to system design. They had just seen what happened in the Articles of Confederation, which did contain a supermajority threshold, and it led to gridlock, not consensus. So they didn't want there to be a supermajority threshold in the Senate. For the entire 19th century, there was no supermajority threshold. Every single bill that came up for a vote in the Senate passed or failed on a majority vote throughout the entire 19th century and well into the 20th century. During the Jim Crow era, the only bills that ever had to clear a supermajority threshold in order to pass were civil rights bills. The only bills that failed on supermajority thresholds were civil rights bills. And it only started to be in the 1970s, 80s, and 90s that it slowly became more accepted for this supermajority standard to be applied to bills other than civil rights. But even then, it was applied at a much lower rate than it is today. Its use on everything that comes before the Senate was something that Mitch McConnell started and has normalized. So to the extent that we accept this as a reality of our political system today, it's important for people to understand that this is a relatively recent development. Those who defend the filibuster talk about Senate tradition, but really Senate tradition is for bills to be debated for an extended period of time, but to eventually come up for a majority rule vote. That is what the framers intended, and that is how the Senate could go back to functioning if senators decided to enact some reforms.
So Kim, based on that history that takes us to the present day, and really this existential fight for our democracy, President Biden alluded to it quite eloquently in his remarks yesterday. Congressman Clyburn talked about the history and really the crossroads we are at for our democracy. For our listeners, can you articulate why it's so important that legislation pass the House, the Senate, and be signed by President Biden to address the Voting Rights Act, to address some of the voter suppression tactics, and why some of the measures like litigation or voter registration just might be insufficient?
Yeah, so we are at a really critical point, and I think the history, as Adam painted out, is crucially important in understanding this point. For the filibuster itself, the debate over the filibuster among Democrats in the Senate who are divided over it. And per discussions that I have, we hear a lot about 2 senators have spoken in opposition to that. I am told that there are more, but they are letting those 2 speakers speak on their behalf. So there is a split. I don't know exactly how deep it is, but when you hear those who speak publicly about it, they point to a few factors. One, this desire to have bipartisanship, that legislation is stronger when it is passed on a bipartisan basis, that is important for the protection of democracy, and you need that consensus building. Without the filibuster, it would be difficult to build that consensus. I think where we stand now and in recent history, we have seen that sort of consensus building has been hard to come by for many years now, and certainly was really never a factor with the respect to the filibuster itself. I think there is this sort of idealized notion that this rule that requires 60 senators to agree to end debate on a bill and to move forward on debate would foster that kind of bipartisanship, would foster that kind of consensus building. We just haven't seen that, certainly not in past history, as Adam pointed out, and also not in recent history. I will give an example. One way that you would think that this would work really well would be for judicial nominees, right? When the president nominates somebody to the federal judiciary, be it the lower court or the Supreme Court, in order to build consensus around that candidate, that 60 vote margin should encourage a president to do, for example, what Barack Obama did in 2016, which is nominate someone like Merrick Garland, someone who certainly is not a judicial activist by any measure, not on the left or right, somebody who he should be able to go to the Senate and talk to Republicans and Democrats and say, look, this is a qualified person, so why don't you back them and give them a strong, lopsided vote in favor. That didn't happen because Mitch McConnell was intent on blocking that nominee, no matter who he was. He was not going to let Barack Obama fill that seat. Mitch McConnell, likewise, when what led to the Senate filibuster being ended for judicial nominees, likewise had blocked a number of Barack Obama's nominees to the DC Circuit and other courts. There was a logjam. Judges were not going through, which, fast forward several years later, allowed President Donald Trump, with the assistance of Mitch McConnell, to put more judges in the federal bench than any other president of any party had done in generations. And that is why we have the far right-leaning federal judiciary that we have today. So the rules have long been broken. The ideals that may have given folks like Joe Manchin or Kyrsten Sinema may have made the arguments that they're putting forward seem reasonable. They're just not the reality here in Washington. It just isn't how it works. So if you want to pass anything, including civil rights or voting rights legislation, the Democrats are in control of the House, of the Senate, and of the White House. And the only thing standing in the way for them to put forward this very high policy agenda, one that should be a top policy agenda, is this one rule that is not grounded in the Constitution, and it is within the power of the Democrats to change if they want to. I will just say one more thing, and we'll probably talk about this more later. You alluded to the Supreme Court 8 years ago gutting a crucial part of the Voting Rights Act, which allowed the Department of Justice to pre-clear rules, pre-clear new laws that you see, like the ones that are being passed by the hundreds in states across the country, to make sure that they were not discriminatory against Black and brown folks before they could go into effect. The Supreme Court essentially, with a decision that said, well, it's not the 60s anymore, we don't really need to do this, gutted that part of the law. Then, just a few weeks back, the Supreme Court was back with the remaining enforcement mechanism for the Voting Rights Act, which allowed, once these laws were already in effect, once the damage was already potentially being done, people to sue, to claim that these laws were racially discriminatory. The Supreme Court raised the standard, made it very difficult to make that case. Essentially, all lawmakers in states have to do is say, well, you know what, we don't want fraud and we're trying to protect against fraud. And more likely than not, that's going to be a justifiable reason, even when there's not a scintilla of evidence of fraud taking place. So this is where we are. Voting is going to be made more difficult, despite the fact that through a pandemic, a record number of people last year showed what could happen when access to voting is expanded. There was no evidence of widespread fraud. More people voted than ever. That's what America and democracy should be about, but that's being rolled back dramatically. And it's really remarkable that this one rule, the filibuster, is the one thing that can make the difference in folks in Congress passing laws that would protect these rights.
So Congressman, given the face of a hostile court system, just last week gutting the Voting Rights Act, where you see sweeping voting suppression laws passed state after state. We've all been inspired by the Democratic legislators in Texas doing all they can to protect the right to vote in the franchise in that state. When restrictions on the franchise are disproportionately affecting communities of color and young voters, you responded. Thanks to your leadership, democracy reform has passed the House. But Mitch McConnell and the Senate Republicans are doing everything they can to prevent it from becoming law. What reforms would you like to see to secure passage of these critical democratic protections in the Senate?
You know, I'm a guy that really can appreciate tradition. But tradition is just that, tradition. It's not law. I think it's high time that we really reform the filibuster. Now, because I am a traditionalist to some extent, I can understand a filibuster taking place on legislative matters to give people time to gather the votes to their side. But I also support what the president says he's supporting, that is what they call a stand-in filibuster. I call it being present to filibuster. And that's what Strom Thurmond did back in 1957 when he broke the record. But now you can sit downtown in a spa somewhere and pick up the telephone and initiate a filibuster and never have to walk to the floor and never have to even show your hands, so to speak. So we need reform. Now, we've done it to keep the full faith and credit of the United States from being jeopardized when it comes to the budget. Reconciliation is a word that's much better used for constitutional issues than for the budget issues. So why not have this kind of exception for constitutional issues that would include the vote? And Kimberly, I know the argument that they use, but I remind people that the 15th Amendment, the amendment that gave the former slaves the right to vote, the 15th Amendment passed by one party. It was not a bipartisan vote. And so this notion that, and I've told this to my friend, the senator from West Virginia, I've had discussions with him about this, and I've told him, you got to check. These so-called, you need bipartisan support in order for a thing to be strong and vibrant and accepted by everybody. It just does not hold water. That's not true. If you go back to the 60s, and you will see that. Now, people have to remember when they tell me about, as Kevin McCarthy did on the floor the other day, we were talking about the monuments, blaming the Democrats for all of that stuff. Well, those Democrats that did that left the party because the majority of the Democratic Party said, we aren't going to be that kind of a party anymore. And we're going to pass these civil rights laws. That's when Strom Thurmond left. He filibustered as a Democrat in 57. He left after the 1964 Civil Rights Act. So that's what bothered me so much about this so-called critical race theory. These theories, or just that theories, they aren't factual, they don't hold water when it comes to the law. So I guess what I'm saying, we got to reform the filibuster. And I just think that, you know, I got a nice little text last night from Harry Reid, you know, and he said in one sentence, "Thanks for what you're doing. It's not a matter of if, but when. The filibuster is going to be reformed. So if we don't do it, if Schumer doesn't do it, the moment Mitch McConnell gets a chance, it's going to be done." And so let's just face that. Down here in the South, we always say the best way to predict future behavior is by past performance. And I think
that's a great pivot to Adam, who was with Harry Reid in 2013 when Senator Reid and the Democrats abolished the filibuster on executive and judicial nomination short of the Supreme Court. What factors led to Reid's decision to get rid of the filibuster then? Do you see parallels to now?
Yeah, absolutely. Yes, Senator Reid is you know, very, very still committed to this fight and to seeing reform through. But I think it gets back to something that Kimberly said earlier, which is that, you know, the reason that senators decided that it was incumbent upon them to reform the filibuster in 2013 was that Republicans were not blocking judicial nominees, were not blocking President Obama's judicial nominees due to their qualifications. They were blocking his judicial nominees because they wanted to see President Obama fail in every aspect of the presidency, and treating him differently than any previous president had been treated by the Senate opposition party, whether they were Republican or Democrat. And you know, what became very clear by 2013 was that it didn't matter how qualified these nominees were. Those who were being blocked had sterling qualifications. Often what would happen was they would get filibustered. And in the cases where we had the votes to overcome the filibuster, Republicans would turn around and vote for these nominees on the final vote. There were over 100 nominees who were eventually confirmed on unanimous votes, who nonetheless had to overcome filibusters. So manifestly, Republicans' objections were not to their qualifications. They just wanted to slow everything down to see that President Obama could fail. And in November 2013, when we decided to reform the filibuster, when senators voted to do so, at that point, President Obama was on pace to have the fewest judicial nominees confirmed of any president going back to Ronald Reagan, and probably before, although the data only goes back to Reagan. So what we did by reforming the filibuster was it allowed Senate Democrats to rush through a wave of confirmations in the year and a half that we still had the Senate majority, and to put President Obama on par with his predecessors by the time that he left office. What people forget about that move is what Democrats gained from that move. We gained a huge number of judicial nominees who were confirmed. It was the most diverse set of nominees ever confirmed to that point. And that left far fewer vacancies for Trump to fill when he and McConnell got back into power. McConnell then went ahead and got rid of the filibuster, and as Congressman Clyburn said, I think, you know, past behavior is predictive of future behavior. He put it better than I did just there, but you know, McConnell, as soon as the filibuster stood in his way, he got rid of it with a flick of the wrist. And the idea that if Democrats had not gotten rid of it in 2013, the idea that McConnell would have then sat around and let Democrats filibuster Trump's judicial nominees without going nuclear himself, you know, I think if you buy that notion, I would like to sell you a bridge in Brooklyn. So all that is to say, if Democrats hadn't gotten rid of the filibuster in 2013, President Obama would have left office with the fewest judicial nominees confirmed of any president in the past 40 years. And then McConnell would have just gone ahead and got rid of himself and confirmed all the nominees that Trump got confirmed anyway. So I think that's important for people to keep in mind as they consider, you know, the risk reward proposition of this move. It is certainly